bringing you the news unfiltered Monday through Friday. And today is Recap Monday. I know I was off last week, had to relocate my office. Hopefully everything looks better to you guys. It looks better to me. I like it. I'm happy about the move. And I wanted to get into some news because, yes, I was away, but I was still trying to get my ear to the ground. It's like, what's going on? So I know this redistricting thing has just been like setting it off. Everybody is losing their ever-loving minds. I mean, just, right? You don't feel like, calm down, calm down. I think you got me. But let's check this video out from CBS Evening News.
Political battle over redistricting. Democrats and Republicans had been in a stalemate to win the House midterm maps. CBS's Aaron Navarro is at the White House with more on that. Aaron.
Good evening, Jerika. The battle over redistricting is swinging in Republicans' favor, giving them a built-in advantage to retain control of the House, despite President Trump's record-low approval rating. Anger boiled over at the Louisiana state capitol Friday during a contentious redistricting hearing, less than 2 weeks after the U.S. Supreme Court allowed the state to redraw its congressional maps, weakening the Voting Rights Act.
We want the map drawn right. That is our right.
In the Alabama State House, protesters disrupted a similar redistricting session. On the same day, Virginia's top court struck down a voter-approved plan intended to help Democrats pick up 4 U.S. House seats.
We're definitely going to try to keep fighting this battle.
21 yeas, 17 nays, Mr. President.
So the bill passes.
With less than 6 months to go before the midterms, there is a seat-by-seat battle for control of the House underway, Republicans appearing to have the advantage. The president's party could gain up to 12 more seats than Democrats if multiple southern states are allowed to finalize their maps.
Yeah. So, yeah, this has been a very contentious argument, right? We can say that. It has been pretty wild. And so I just wanted to jump into the conversation because I'm telling you, I went off last week and I was like, oh my gosh, all of these things are happening all at once. Okay. So I went back and I was like, okay, let's check out the voting rights, right? Let's go back to, I should say, the beginning, right? So it was regarded as one of the most effective pieces of civil rights legislation in U.S. history. President Lyndon B. Johnson signed it into law August 6, 1965, in direct response to violent suppression of Black voters in the South, notably the Selma marches and Bloody Sunday. Its core goal was to enforce the 15th Amendment, which prohibits denying the right to vote based on race by banning discriminatory practices that kept many African Americans or American Negroes, I prefer that one, I prefer that term, and later other minorities from registering and voting. So the intent, let's go back to the intent of the law. The intent of the law was to protect emancipated slaves, right, and their descendants, so they can now vote in peace. Again, let's just talk about how we have a First Amendment that says all men are created equal, but then we have to have civil rights to protect a certain segment of people. It's stupid. It's stupid. I'm telling you right now, it's dumb. It creates unnecessary arguments. It creates an unnecessary rift. Either we are all created equal or we're not. That's it. But when you inject civil rights, you are always injecting a way to demonize people, right? Keep a subclass of people because then, I guess we have to give you rights because you need to be protected. No, I need to be equal with you. But that's not what people want. They don't want that. They don't want people equal. They want a subservient class. Now, a lot of you might sit out there and get mad, but we need our civil rights. No, we don't. We've been indoctrinated to believe that we need them. Again, we live in a country that says all men created equal. That's it. That's it. And for those not treating people equally, there needs to be repercussions, right? You cannot discriminate. Oh, well, that's where civil rights kicked in. People should have been punished, right, based on discrimination. Period. Because they're like, but civil rights that brought about those laws. It did bring about some of those laws, but then those laws were unfortunately diluted, right? And I don't want to say that they're meaningless, but they don't hold and carry the weight that they once had. Here's my thing. If we're supposed to all be created equal, right? We're not supposed to judge based on race, sexuality, all these other things, then we're not supposed to do that. Then why are we doing that? Because we injected civil rights and you were able to fragment the equality that we all should have because we're all created equal, right? Yeah. We'll one day get there. One day. That's my. But back to this, the Civil Rights Act. So, yeah, and this other minorities, it's stupid to me. It was written for one specific group of people, and that's who it should belong to, not everybody else. Stop your nonsense. Anyways, so the law has two main types of protections: general, which is nationwide, and special, targeted at areas with the worst histories of discrimination. Okay, and you could say it's the South. There might be some places in the North as well, right? So Section 2 is a general nationwide ban. This is the permanent core of the law. It prohibits any state or local government from imposing any voting qualification or prerequisite to vote or standard practice or procedure that denies or abridges the right to vote on account of race, color, or, after later amendments, language, minority status. It applies everywhere in the United States and allows private citizens or the Justice Department to sue, originally focused on intentional discrimination, right? Congress strengthened it in 1982 to include a results test. Discriminatory effect matters, not just intent, using the totality of circumstances to assess vote dilution, cracking or packing minority voters in redistricting so they have less chance to elect their preferred candidate. Cracking or packing minority voters. What have Democrats been doing for decades? That's what they do. They take the most populated, dense areas that are Democrat, and they couldn't carve them out so that there's participation. And they've done it based on race. It's interesting to me how we can be 13% of the population, but 80% of the problem. It's weird. It's weird. But that's where I'm at. And I know some of you guys might be out there going, yeah. It's crazy. It's insane. Okay. So it does not guarantee proportional representation by race. Okay, anyway. Sections 4B and 5, special pre-clearance requirements. These were the law's most powerful and controversial tools, right? Section 4B created a coverage formula based on 1960s data. Jurisdictions that use literacy tests or similar devices had lower voter turnout registration under 50% were covered. This mainly hit southern states: Alabama, Georgia, Louisiana, Mississippi, South Carolina, Virginia, plus parts of others. Section 5 required these covered areas to get federal pre-clearance approval from the United States Attorney General or a DC federal court before any chance to voting laws, procedures, or district maps. The jurisdiction had to approve the change, and approved the change had neither discriminatory purpose nor effect. The no retrogression standard, right? This stopped discrimination before it could take effect. Okay, my goodness. So other immediate tools: nationwide suspension of literacy tests and similar devices, authorization from federal examiners to register voters and federal observers at polls in covered areas. Later expansions in 1975 added protections for language minorities, Spanish, Asian, Native American voters, and required bilingual election materials in certain places. See, that's where it gets disgusting. Because if you are a naturalized citizen, you are required to read, write, and speak English fluently in order to become a naturalized citizen. So why would anybody need a translator? It was initially put in there because Black Americans did not have access to education. And you would say, well, 1965, they should have been more educated. Should have been. Should have been. But they did not want language to be a barrier. Interesting that they said they didn't want language to be a barrier. Every time I look back at some of these bills, it was a trap to make sure everyone else was able to use the suffrage of the American Negro to basically weave their way in. Because why in the world will we have protections for people who aren't speaking the native tongue of English in the country? Huh? You shouldn't be able to vote if you cannot speak English. How are you demanding the right to vote and you can't speak the language? That means you're not a naturalized citizen, because you're required to actually take an exam that's in English and you got to read it out loud. I mean, there's a lot of stuff you got to do to become a naturalized citizen. So what are we talking about? This is what makes it disgusting, in my opinion. So, impact. Within years, Black voter registration in the South skyrocketed from single digits to over 50% in many states. It dramatically increased minority political participation. Let's see, the pre-clearance formula and requirement, Section 5, were reauthorized multiple times. Yeah, they did it multiple times. Why? In 1970, 75, 1982. You got to remember, 1986, there was amnesty. So between 70 and 82, there was an influx of people coming to this country, whether they were coming legally or illegally. And then we got emancipation in 1986 because there were just so many people here. Illegally, they were like, we can't remove them. Yeah. But always with the same old 1960s data. Now in Shelby County versus Holder in 2013, the Supreme Court struck down the coverage formula as outdated, effectively ending free clearance nationwide in a 5-4 decision. This is often called the first major gutting of the Voting Rights Act. Now, Section 2 remains the main surviving enforcement tool today. Now, the recent controversial court decision in Louisiana versus 𝗏𝗏𝗧, this is the decision currently generating widespread controversy in 6-3 ruling. Justice Alito wrote the majority opinion, joined by the conservative justices. Justice Kagan dissented. I'm joined by Sotomayor and Jackson. The court struck down Louisiana's 2024 congressional redistricting map that created a second majority Black district. Louisiana had drawn the map after lower courts found its previous map diluted Black voting strength in violation of Section 2 of the VRA. So that's interesting because, like I said, they keep going back and forth with the race game. So let's just see. So drawing the second majority Black district constituted an unconstitutional racial gerrymander. I thought we weren't supposed to be doing these things based on race. I thought you couldn't discriminate based on race, but you're doing the maps based on race. It's really weird. Like I said, to me, those are the weird parts. So, the Black District constituted a constitutional gerrymander under the Equal Protection Clause of the 14th Amendment. Race had been the predominant factor in drawing the redistrict, which triggered strict scrutiny. So even though the map was drawn to comply with Section 2 of the VRA, satisfying Section 2 does not automatically provide a compelling governmental interest that justifies race-based districting. The majority said Section 2 must be interpreted to avoid colliding with the Constitution's prohibition on using race as the main factor in redistricting. Like you cannibalize yourself. This is cannibalization of legislation. Because in one breath, you're saying, hey, we need to protect people that look like this. And in another place, it's saying, well, you can't use that for just how you look. I'm telling you, the race game is crazy. It's crazy. Very interesting. But we need to stop playing the race game because, again, we are in a country that has a First Amendment that says all men created equal. Why do we need some rights if all men are created equal? And I know for a lot of people, it might seem like a rhetorical question, but it's a question that needs to be asked and answered because all civil rights has done is created more argument and less protection, in my opinion. Because the people that it was supposed to protect, it doesn't protect them at all. So what is it doing? You know, you may not like Hillary Clinton, she's not always at the top of the list. But the one thing I can't respect that she said, there were a group of young melanated humans, because I'm not going to call everybody American Negro, I'm not sure their lineage, but they went to her and they said, we need to create laws to demand people not be, basically discriminatory. She's like, you cannot legislate people's feelings. You can't tell people how they can and cannot feel with legislation because, that's going into, messing with someone's personal rights. Right? We have freedom of speech, freedom of religion. You cannot dictate that, some people's rights. Anyway, back to the conversation. You can't do that. You can't dictate that. She said, but what you can do is you can create protections using the laws. The part she left out is you can't make them race-based. You can't. Which is why you get the terms marginalized groups, minority groups that need protection. Emancipated slaves got the 1866 the 1866 Civil Rights Act because they were not considered citizens of the United States. So that's how that came into being. But they still, in my opinion, by putting the civil rights in place, made them, or me, the descendant of slaves, second-class citizens. Because I'm not covered under the First Amendment that says all men are created equal. I'm descendant of a slave, which means I fall under civil rights to give me a right to be here in the country and be treated in a civil way. But the Constitution